A new dawn, a new horizon of healthcare delivery and patient safety. We have a goal, a noble drive.
Hand in hand, step by step, we will thrive.
To march ahead together for a bright and shiny future with patient safety and quality healthcare. We are CAHO, your healthcare companion, standing right by your side. Joining hands for building a vision, shaping a culture for patient safety.
Setting up standards with best foot forward. Won't ever leave no stone unturned.
We wear our pride on our sleeves, work with passion like a breeze, train people, enhancing their skills, spreading the message of quality healthcare for safer patient care, a better nation.
We have a goal,
We have a goal,
a noble drive.
noble drive. Hand in hand, step by step, we will thrive. To march ahead together for a bright and shiny future with patient safety and quality healthcare. We are CAHO, your healthcare companion, standing right by your side.
Good evening, friends, and this is my greetings from all of us at CAHO. Thank you for joining this program. And I think this is one of the very, very important topics that we are going to discuss today, because this is something which is going to impact us all, and we know very little about it. So we have today to introduce the speaker, our moderator, Mr. Anand, Dr. Anand Sivaraman, in fact, and he is a chemical engineer by background. In fact, one of the, I would say, guy who has done his master's doctoral degree and the postdoctoral degree from the very prestigious MIT, the Massachusetts Institute of Technology from Boston, and he returned in 2005 and is the MD and CEO of Remedio Innovative Solutions. And he's working in the field of creating some very, I will say, interesting solutions which are AI-based, especially in the field of eye care, where even non-specialists are able to kind of help. So he is one of the right persons we thought today to listen and to talk about and to moderate this session of the data protection bill, which has been introduced by the government, but we understand very little. To demystify it, we have Mr. Kalra. So over to you, Dr. Anand Sivaraman, to take this forward. Thank you so much for being here.
Thank you so much. And I think it's extremely relevant, and thank the CAHO Governing Council for organizing this session. even as we get into a world where data is extremely important in the way it is managed, used, stored, as well as transmitted. The data protection bill is something that's been now enacted into an act and a law. And as Dr. Vijay rightly pointed out, there's a lot that we wish to seek to learn about the bill, what it covers, and I think there's no better than Mr. Lalit to take us through this. And I just wanted to very quickly be able to introduce Mr. Lalit Kalra. Suffice to say that just as we have super specialists when it comes to doctors, I was telling Mr. Lalit that he's a super specialist when it comes to data privacy. As someone who's leading the technology practice at ENY, and is someone who's actually gone into the depths both on the strategic side as well as the operational side when it comes to data protection as well as data safety. He leads data protection and privacy solution for EY India and has more than 16 years of experience in doing this. What has been very interesting when I was having a conversation with him is not only does he focus on the strategic side, such as cyber risk, security incident response, and governance, but is also equally involved on the operational side, such as vulnerability assessments and how do you start looking at these within the telecom, media, and technology sector. I thought healthcare is possibly going to be something new to him, but I was pleasantly surprised when he said that he already has someone that is a very large corporate client that he works very closely with in the healthcare sector as well. So looking forward to really having an engaging session today. And as I said, he is a super specialist with a postgraduate in management and Bachelor of Engineering, but is a certified information privacy technologist, also called CIPT, and a certified privacy professional or CIPP. So without further ado, looking forward to start the session.
Thank you, Dr. Anand, Dr. Vijay, and the entire team of CAHO for giving me this opportunity. So like Dr. Vijay mentioned, that this is a bill which has been recently passed by the government, and as individuals, or I would say the term which our Honorable Prime Minister has been using, as the digital Nagariks of this country, we all should be aware of what the new law talks about. Why are we, so first is what was the reason for it to come into existence, and what does an organization, whether it is a hospital or a technology or a startup, that needs to do so that they are compliant with the law of the land. So first of all, I would take everyone to a little back in history. So the first data privacy law that came in Germany in 1977, followed by France in 1978, then followed by Switzerland and Australia in 1988 and 1992. In fact, Bangladesh and Nepal had a data privacy law in 2019 and 2022. So the passing of the law in India in 2023 has actually brought in India on the world map alongside the countries which have a current data privacy law. And you'll be surprised to know that out of the 194 countries that we have across the globe, over 134 have a data privacy law, and around 15 more of them are in the draft stages, and the rest are in the process of drafting. So this is a significant milestone for us as a country to put alongside the world leaders of the world. Now let's talk about what are the journey that took place before it actually became a law. So it essentially goes back to 2017, which to a Puttaswamy judgment case. It was actually not a case with respect to privacy or anything. It was essentially focusing on issue of Aadhaar and the Aadhaar Act. So in that case, Supreme Court declared privacy as a fundamental right, and that triggered the need for a data privacy law in India. So after 2017, committee was formed, and Justice Shri Krishna was the leader for that committee. And there was a report which was submitted in 2018, which was called as a Personal Data Protection Bill. To a large extent, it was similar to what a law that we have in Europe called EU GDPR, which is General Data Protection Regulation. So it was pretty much similar to that, but it had its unique taste of India. And then there were different committees which were set up. In 2009, there was a joint parliamentary committee which was set up, and multiple versions of that came out. In 2021, the government came out with a version which included non-personal data also into the realm of the Data Protection Act. But later in the 2022, around August, the government shelved that version and said that we are working on a new version, which is a simpler version and which would cater to the needs of India. And that's when a newer version was created. The latest version that we have is India's Data Protection Act. It's a 20-pager document, pretty easier to read and understand. And it is the first act across the globe in terms of privacy, wherein she has been used as the mode for gender neutrality, thereby showcasing the focus that the government has on diversity and inclusion. Now, before I get into the details of the law is applicable to data which is available in digital form, which has been collected in digital form or collected in hard copy, but later digitized. The law is applicable to all the companies across the globe which are providing goods or services within the territory of India. It is not applicable to data which is used for personal or domestic use. For example, myself and Dr. Anand, we shared contact details. We connected over a call to discuss what should be the flow and so on. That's the data which is being used for domestic purposes. So that does not come under the purview of the law. The other type of data which does not come under the purview of the law is a data which has been made public by the data principal or is publicly available. So those are the two types of data which does not come under the purview of the law. Now, before I go into the details of the law, I will talk about some of the key components or key terms that the law has used. So the first party that we have is a Data Protection Board. This is essentially the apex body which is responsible for enforcement and implementation of the bill across India. Then you have a data fiduciary and a significant data fiduciary. These are the entities which define the purpose and means for collecting and processing personal data. So when you talk about security or when you talk about any other act or thing, it has a lot of it is black and white. But in case of privacy, it is a lot to do with intent, context, and purpose. So these three words play a crucial role in determining what law is applicable or not. So a data fiduciary is the entity which is defining the purpose and means of collecting and processing personal data. Now, what do you mean by personal data here? Personal data essentially means the data which can help an organization to uniquely identify an individual. That could be single element, that could be multiple combination of elements like a name, mobile number, email address, LinkedIn profile, so on and so forth. Any information which can help an organization to uniquely identify an individual shall be considered personal data. Now, any entity which is processing the personal data of an individual is a data fiduciary. Now, there is a category under data fiduciary called significant data fiduciary. Now, this is also unique in the India version because nowhere across the globe they have categorized companies into two parts. Now, a significant data fiduciary essentially is the company which processes large volume of data. It's the company which processes high sensitive data. It's the entity which processes data which may result in risk or harm to the data principal, or it can impact national security or electoral results. So those are the key parameters which define which company would be categorized as a significant data fiduciary. Then data principal is the individual whose data is getting processed. So these are the 4 key terms. The 5th key term, which is not mentioned here, is a data processor. A data processor is the entity which is working on behalf of a data fiduciary. So for any company, all its vendors, subcontractors would be processors, and they would have to do all the work which the fiduciary tells them to, based on a contract between the fiduciary and data processor. So a contract becomes important to ensure that the processor implements the control that the company wants them to. So I will pause my stop sharing here. I'll switch my slide to another one, which is a simpler version of what the bill talks about. So I've covered the terminologies, which makes it easier for everyone to understand. Now, under the law, there are 7 key requirements, and I'll make it simple and faster. That should be divided between data fiduciary and significant data fiduciary. 4 requirements for a data fiduciary, 3 additional for significant. And based on our understanding, hospitals and the organizations which are processing data related to healthcare would fall under the gamut of significant data fiduciary because the data is sensitive and of high risk. So the first requirement that a data fiduciary needs to comply with is a notice. Entity needs to give a notice whenever they are collecting data. The entity can only collect data along once they have the consent of the individual to do so. The consent has to be freely given, informed, unambiguous, and shall include an affirmative action, which means that I should be clearly clicking on something to showcase that I'm giving my affirmative action to process that information. The notice requirement that the law talks about is retrospective in nature, which means an organization should reach out to all the data principals data that it has and tell them how they are processing data, what is the purpose for processing data, what are the rights that an individual get, and how will it retain that data, for how long it will retain that data. So these are 2 mandatory requirements: notice, consent. The third mandatory requirement under the law for a data fiduciary is a reasonable security safeguards. Under the IT Act, ISO 27001 certification is considered as a reasonable security safeguard. So we are right now assuming that this would be carry forwarded for the organization so that they comply with the law. There is a mandatory requirement for organizations that in case of a breach, the organization need to send a notification to the individual as well as the data protection board within a defined period of time. Now that defined period would most likely align with what the certain requirement says of 6 hours, but that is something which is mandatory. The fourth requirement that the law talks about is storage period limitation. Now you would have seen that in organizations, people store data for lifetime. Under the law, the data cannot be stored for lifetime. The data can only be stored for the period for which it has been the purpose. So if I share data with a company for, let's say, selling my car or getting my test done, unless a laboratory has a legal requirement or a regulatory requirement to retain my data for 5 years, 10 years, or whatever that timeline is, they should be deleting my information after the purpose is fulfilled. So that's a key aspect that organizations will need to undertake. So 4 mandatory for fiduciary: For a significant data fiduciary, appointment of a data protection officer is mandatory. It is the individual who is responsible for implementing privacy program within the entity organization, and the DPO should report to the highest level of authority in the organization. The organization should do a data protection impact assessment. This is similar to a risk assessment that the organizations would be doing, whether it is in terms of operational risk assessment or a security risk assessment. But organization should do a data privacy impact assessment to find out what are the gaps that they have and what are the controls that they need to put in to implement. And lastly, they need to appoint an independent auditor and undertake regular audits. So 7 key requirements which are mandatory for organizations. Similar to other laws, an individual gets certain rights. So he has a right to erasure, he has a right to access, correction, grievance redressal, and nominate someone. So the right to erasure is critical here because an individual can reach out to an organization and tell them to delete data, unless there is a regulatory or a legal requirement in place. The law talks about tougher penalties if the organization is not following the law. The cumulative penalty that the law put forward is up to 850 crores that the company can be levied on. One key aspect about processing data for children is talking about a verifiable consent of the parent before the company can start to process data. This would be critical for all the labs, all the hospitals, wherein children data is processed, and what controls should be implemented to safeguard that children data specifically. So this is a capsule of what the law talks about, Dr. Anand, in summary. Then the steps that an organization should be taken are essentially divided between starting with doing a current state assessment to where do you stand, then defining a privacy framework, doing data discovery to identify where all is the data, and then implementing those safeguards and mechanisms. So I'll stop here and give the stage back to you for questions, Dr.
Thanks so much, Lalit. I know there's a lot that's been covered in a fairly short time of around 20 minutes. But I'm sure there are going to be questions around what this may particularly mean, even as we know that the poll was about a summary and a quick summary, and I guess this is a quick summary in terms of what it means. So let's start taking questions. I think first we have one from, I think, Dr. Ganpati. You can unmute yourself.
Thank you very much for this information. Now, Confucius said 2000 years ago, the greatest fool can ask more questions than the wisest man can answer. And I'm going to bombard you with some questions in my ignorance. Now, this is specifically referred to, I head the Apollo Telemedicine Foundation. We are one of the largest telehealth services. Most of our clients are the government, public-private partnerships. We do almost 18,000 to 20,000 teleconsultations every single day. Now, this data is, I presume, the actual data is owned by the patient, but it is the government is the one who is funding this entire project. The Apollo Hospitals is only an executor who implement what the government wants. Now, this is a very tricky situation. As per the present law of the National Medical Commission, it is mandatory for any clinician or a hospital to store records for a minimum period of 3 years. But again, the individual clinician uses his judgment and discretion based on the specific clinical problem. Now, for example, I am a neurosurgeon, or I was a neurosurgeon. Now, to me, I certainly need to store data to see whether a tumor has progressed, regressed, etc., for 5 years, 10 years, 15 years, 30 years if necessary. Now, with more and more EMR, hospital information systems, the drive for digital health, etc., the use of paper records is progressively becoming less and less. Now, I would like to have your opinion, sir, on this complex situation where it's a public-private partnership. So who owns the data? Is it the state government for whom we are implementing a project? And so could you elaborate on that? I mean, I have several more questions, but I will stop with this for the moment.
Sure, Dr. Ganpati. So the first part, in across the laws under the globe, there have a what do you call it? Component called a joint controller, which essentially means there are two entities when they jointly come and decide who would collect the data, who would do what, then both of them become a joint controller. Now, in India's current law that we have, we don't have a concept of a joint controller. It is a data fiduciary and a data processor. In the scenario that you're talking about, the government would have told you that, okay, you go ahead and provide, set up guidelines, set up components and the ecosystem for providing telemedicine and telehealth services. Now, it is Apollo in this case, which is deciding what would be the means of providing these services, what would be the purpose of collecting that data, how would that data be retained, and you are the front face for the government or as in that partnership. So you would play the role of, and this is, I'm sitting outside without looking at the technical details, you would play the role of a data fiduciary who would, when you are collecting data or interacting with patients, would have to give a notice, will have to take consent and specific and so on and so forth. Then the next question that you talked about is that you need data for the mandatory requirement is 3 years, but you need data for treating a patient for, let's say, 30 years or 10 years. Now, in those specific cases, the purpose becomes crucial. Like I said, intent, context, and purpose. These three things are very critical when it comes to privacy. And because you have a lawful purpose for which you need to refer to that data, therefore, the retention guideline can be depending on the purpose for which the data is getting processed. So there is no law which says that you cannot retain that data, but it's like it's saying that I am a patient of Dr. Ganpati today. I get myself treated for 3 years with you. But tomorrow I change my doctor, I change my city, I change my doctor. As per the law, you have to store that data for 3 additional years. But after the 4th year, I come back to you and tell you that, okay, I want to delete the data principal request. Can you delete my data? In that scenario, because I'm no longer a patient of yours, you would have to delete.
If I can interrupt, in the real world, it's almost impossible or very, very unlikely that patients are so sophisticated to ask a doctor to delete the data. They honestly don't even know that the data has been stored with me. What I want to know is it a criminal offense if I do not delete the data, or is it optional? Number one. Number two, most of us are involved in research, and the government also encourages this. We anonymize the data, particularly public health data, when the entire government's policies depend entirely on research and on analysis. So does the data protection bill in any way cause more problems than what the current thing is on using data? I'm talking of data for a few million. I have data of almost 14 million records now. Now, is there any change in this for using it for research? Of course, anonymizing the entire data.
So, so I'll go one by one, Dr. Ganpati. So the first part, there is no criminal penalty. The second question is it mandatory to delete the data? Yes, it would become mandatory. My voice is echoing. Just one. Yeah. So it will become mandatory to delete the data if I have raised a data erasure request and you as an entity do not have any legal or regulatory obligation or purpose requirement to keep that data. It would become mandatory to delete the data. Third part, clinical trials for research is exempted under the law. But if you are not doing clinical trials but using data for research, anonymized data can be used, although it is not specifically called out in the law. But the moment you anonymize data, it is no longer personal data because you cannot associate that data to an individual. So therefore, it becomes out of the scope of the law. I hope I've answered all three.
Sorry, I let others talk. One last question. Under the circumstances, do we need to have a specific unique data protection officer, as you mentioned? In other words, a specific entity, organization offering teleconsultation services in large numbers. Is it mandatory to have an exclusive data protection officer?
Dr. Ganpati, the specific needs or the specific numbers for volume of data would come into the rules. But based on our experience, 99% of the cases, the hospitals would fall under significant data fiduciary, and therefore a DPO would become mandatory. However, there is one icing on the cake, Dr. Ganpati here. So the Minister of State, Mr. Rajiv Chandrasekhar, did a public consultation last week, and people are asking him about what are the timelines for implementation. So he said there are 3 timelines that they are targeting. First is state-run organizations or states which are low on digitization but have low personal data. Second, he said MSME or hospitals which have a lot of personal data, high risk data, but are low on digitization. So these 2 entities would get a longer implementation time, while the third entity, which is rest of the world, the big tech companies and the startups which have set up themselves, would get around 6 months to implement.
Thank you very much. Thank you. You've been extremely informative.
Thank you.
Thank you so much, Lalit, and thank you so much, Dr. Ganpati. I think that brought in a lot of clarity with those questions. I was just going to take a couple more that have come in now next, and those have to do around informed consent. And the question is consent necessary also for offline data collection? That is one, and maybe I'll add a part to it. There's always the question of interpretation that comes in when something is said as freely given, informed, and unambiguous. So how is the bill ensuring that it's not open to interpretation, and what are the steps that an institution would need to take to ensure compliance with those 3 words? So 2 parts to the question. Is consent necessary for offline data collection? And the second is eliminating the ambiguity around what's informed and unambiguous consent.
So to answer the first part, Dr. Anand, consent, the law is applicable to data which is in digital form. If you collect data in hard copy but later digitize it, that comes into the purview of the law. And for that, consent is mandatory. So if my intention is only to keep that data in hard copy and not ever digitize it, then consent will not become mandatory. But if I have an intention to digitize it, then consent becomes mandatory. Whether I'm collecting offline or online does not make a difference. The second part of the question essentially focuses on how do you ensure that it is not open to interpretation. Now, that's $1 million question, Dr. Anand, because under GDPR also, it has the same attributes. And today morning, I was on a call with another organization which said that we do a lot of marketing activities. And using those marketing activities, whether it is a health tourism, whether it is some sort of medicines that we want to sell and so on and so forth, that's our living. I cannot do away with my living, so I need to figure out a way how I keep on using the data, at the same time comply with the law. So combination of different components would have to be created. But as the law gets more stricter, we would see consent getting more formalized, consent getting more streamlined for different purposes.
Understood. Makes a lot of sense. And I think precedence then starts getting set once those start. I think I'm just hoping Mr. Balihar Singh that answered your question. If you have a follow-up question, please do type it either in the Q&A or in the chat. The other question that's now come up, Lalit, is on the are there any details that you may be able to share on exceptions made for legitimate use? So what are those exceptions? Are there examples that you may be able to give for those exceptions? The rider on the question is also saying, I understand that healthcare is classified as a legitimate use, that is research, etc., is considered legitimate use, or are there certain exceptions made for legitimate uses that are very well defined?
So I will bring my screen again. It will be easier for
Sure.
everyone. Yeah. So what you see on the screen essentially summarizes the legitimate uses that are mentioned under the law. First is the data principal has voluntarily provided her personal data. This is the main reason which would be applicable to corporates. The second is any subsidy, benefit, service, certificate, license, or permit. This is essentially those services, the maternity benefits that the companies give, the state, the ration that the state government give, those benefits and services. Performance of any law in the interest of integrity of India. Compliance with any judgment. In case of epidemic, outbreak of disease, or any threat to public health, responding to a medical emergency, and taking measure to ensure safety in case of disaster. Now, apart from the last three, there is tons of personal data which gets processed by hospitals. And out of, apart from these three, there is no other legitimate use which allows hospitals to use data as they want. So there is a purpose involved. A person goes for an OPD checkup. Once the OPD checkup is done, the individual had a fever, the fever goes off. And unless, like Dr. Ganpati mentioned, that there is a mandatory requirement of 3 years, post that the hospital has no purpose for keeping that data. So that needs to get deleted. And the other piece you will have to see is there are multiple services which hospitals provide today. They will have a testing arm, they will have another telehealth arm, telemedicine, so on and so forth. So for those services, the data, where is that data coming from? Is the data which has been collected in OPDs or different patients which is being utilized? So that cross utilization of data is not a purpose in any of the legitimate uses, if you would see. The legitimate use essentially talk about treating for epidemic or disease or medical emergency, not for those purposes. So going by that logic, there would be a consent requirement for specific purposes and usage.
Understood, Lalit. That drove a lot of clarity, I think. And again, Bhargav Susli, in case there are any follow-up questions, please bring that on to the chat as well.
Anand, can I ask a question? I just
No,
button. Yeah, no. So, I mean, it brings us that can the consent right in the beginning be explanatory to the patient that, for example, your data naturally will be used for cross, let's say, you will require additional etc. to restore health. Am I allowed to share it? I mean, to say that every time I am going to go and get consent, I'll tell you that it will become a disaster situation for the patient also. Forget about the hospitals. Because in the beginning, yes, there can be a very nice explanatory. We can even have a video explaining the whole thing. So what can constitute a good, valid consent so that the hospitals are about to continue the way they function, the way they are functioning? Idea is not to create roadblocks in the functioning. So how can you help us with it?
Absolutely, Dr. Vijay. So the consent is not every time required. Consent is to be taken at the time of data collection only. So at first, when I am becoming a patient and you can take consent for whatever purposes that the hospital requires. You don't need to take that consent unless there is a change in purpose. So today, you did not have a telemedicine branch, assuming tomorrow you want to start a telemedicine branch. and you say that, okay, I will use this data, that's where you would need a consent if the consent was not taken already. But it is not to be repeated every time.
Understood. So would the right summary be that if it's a fairly broad scope of use that is designed at the time of the data collection for consent, is that what you're recommending? Is what I understand, which also brings in Dr. Vijay's
So that brings to my previous point, and the consent has to be specific.
Okay.
It cannot be a motherhood statement saying I will use the data for my whatever purpose I need. You can take 5 consent from the patient, but those 5 will have to be specific.
Got it. Dr. Vijay, you had a follow-up question or?
No, the specific now, for example, this person is being investigated. Now, his wrong reports, number one, the panic reports, as we call it, are normally, naturally escalated to all concerned physicians. So, for example, somebody has been admitted, his blood sugar comes very high. His blood sugar report has to be communicated to the people concerned in the department for taking action for that high blood sugar. So that is one. And I'm saying that, therefore, he, over a period of time, today all his record is all getting digitized, and the situations on a day-to-day basis will keep on. So tomorrow there is a need to consult a nephrologist, for example. So therefore I now going to say that I'm going to use your data and share it with the nephrologist. Or I could have said in the beginning that, look, you are being admitted. There is a possibility that some specialists will need to be consulted, etc. Are you giving me consent for sharing your data, or you want me to come back to you individually? Is that kind of a...
You can say that in the beginning. You can say that in the beginning. And also, the key component, like someone asked the question on legitimate use, if it is responding to a medical emergency involving a threat to life, you do not need a consent there. So the scenario, the blood sugar comes very high and it is a threat to the life, then you do not need a consent. But for all practical purposes, you would take that consent at the beginning and take care of it for the rest of the other scenarios.
I think we need some people like you to take up this scenario, healthcare data, in particular with the government, that they need to kind of come out with some more clarity, both for patients and for us, really speaking, to make it happen. Otherwise, we are actually, it will be just other inspectors coming and doing things all right, that you have not shared this data and that data, and that is what will happen. We need people like you to make a case.
Anytime with you.
Thank you, Dr. Vijay. So just a quick summary saying that specificity, and even as we get the specificity, making sure that there are multiple sets of specificities brought in. Moving on quickly, there are a set of many questions that have come up, which all possibly are coming from startups who use health data in the field of AI development. And there are a set of questions related to that. And if I were to summarize a set of questions there, the question is, when AI is being developed, what is the consent process involved in the use of de-identified patient clinical data? I think to a certain extent, this is similar to the point that Dr. Ganapathy was bringing up in terms of research purposes. But there, the research may eventually result in a commercialization, right? So the question is, what is the consent process that has to be used if it's being used by someone who may not necessarily be the point where the data is getting generated? That is, a hospital may be doing the test, but the data necessarily is being used by somebody else.
So it's an interesting case, Dr. Anand, because in today's world, a lot of startups utilize the data which has been collected by a data collection agency. So in a normal scenario, you would rely on ensure that when you sign a contract with the data collection agency, you put it on them that they will ensure that the data which is collected has valid consent, and whenever you start to use that data, a notice is given, so on and so forth. But specifically, if you see the question, it is for de-identified data, which means that the data is anonymized. Now, the moment the data is anonymized, it goes out of the purview of the law. So putting generic data, putting data which cannot be uniquely identified to an individual, can be utilized for whatever purposes you need, as long as you cannot identify an individual. So there are two terms, pseudonymization and anonymization. Pseudonymization essentially means that you have reference to the individual in one database, and then you use that particular ID or a generic data across your different system. That's pseudonymization, wherein you assign a particular key. Anonymization is totally anonymizing the data, putting gibberish in the database so that you cannot identify a particular individual. So that's the difference between the two. A pseudonymized data would come under the purview of the law. Anonymized data would go out.
Understood. So the data collector has to ensure that there is the informed consent if a personal data is being collected as part of the research.
Absolutely.
In the
Absolutely.
absence of, if it is those two contexts where they are de-identified, then the law then does not apply. Understood.
And on the next question, I'll read that, Anand. So these, I think, Mr. Bhaga, to an extent, it got answered in the question that Dr. Vijay asked for, that when an individual is getting admitted. So right now also, when somebody gets a MRI or somebody gets a CT scan, there's a long consent form which gets signed anyways, which is an explicit consent today. But the other pieces can be taken when the patient is admitted in the hospital and ensure that the hospital is compliant to the law. And so there is no concept of implied consent here in the law. You have a consent and then you have a legitimate usage. There is no concept of an implied or an explicit consent. GDPR uses the word explicit consent. The word implied consent is not prevalent in the law, Indian law. So if you are using it for certain medical emergencies, then it would fall under legitimate use only, no implied consent. And the next is the hospitals have to share a lot of data with statutory, with civil. The data will be hospitals only. So once the data hospitals share that data with respective statutory authorities or statutory bodies, and assuming there's a breach, if it can be proven that the breach happened through the hospital ecosystem, then hospital is liable. Otherwise, from where the breach happened is the entity that would be liable. Having said that, who's responsible for data is, because if I gave it to the data to the hospital, I would be, as an individual, I will be holding hospital as accountable. So whenever hospital is sharing data with statutory authorities or police authorities, they should have appropriate disclaimers in their communication that happens with them. I know that you cannot sign a contract with them, but there should be appropriate disclaimers that happen. Now, the next question that we have from Dr. Mukta on cross-border data transfer. So in this context, the law is very clear and very streamlined. The government has said that you can transfer data anywhere across the globe unless it is prohibited. So instead of following a whitelisting approach, the government is following a blacklisting approach. They will tell us the list of countries where the data cannot be sent and processed. Rest everywhere it is allowed. So those list of countries and everything should be out by end of next month. So that will give us clarity on which are the countries where the tourism and things cannot happen. Next is whenever new patient comes while they register, there is a consent or not. That talks about treatment. Yes, that can be considered. So the question that we have essentially is, when an individual patient comes in, they already consent to authorization. So alongside, if you add, that can be considered as consent. So the last question on every organization such as IMA has data of its members, and the data is also shared among other contexts for this under the law. So IMA would have to now take consent of of its members to ensure that they comply with the law. And whenever IMA is sharing in the consent that IMA takes, they will have to ensure that this is one of the purposes stated that they will share the data amongst organizations to comply with the law. What all could be the sources of anonymized data? So there are different platforms which you can use to anonymize the data in your databases. So there's no as such sources of anonymized data. And yes, you can anonymize your own data and use it for trainings.
Thanks, Lalit, for making my job much easier by just reading through it and having those questions answered. I know we have 5 minutes left, but I just wanted to delve a little deeper on one key point that we may not have covered. One was the point that you raised on, I think, the importance of hospitals and institutions when they share data to ensure that they have disclaimers so that tomorrow the breach or the leak is not as a result of them. I think that's an important point that is relevant to the group. The last point, which I think merits some discussion, is on the data protection officers, the independent data auditors, and the data protection impact assessment, right? Now, if you take something like the data protection impact assessment, are there going to be a set of certified organizations that would be able to do that? And with respect to data auditors, is the bill clearly articulating who can be a data auditor and what would be the source for organizations to hire them?
So on the second part first, Dr. Anand, when the rules come in, we would see, and the data protection board gets set up, we would get more clarity on who can be an independent auditor. But based on our previous experience, we see a similar line of thought wherein a certain empaneled auditor can be an independent auditor. So we see the government following the similar path on that perspective. And for doing a DPIA, there are consulting firms, there are law firms, there are many other companies that can do a DPIA. And so it is nowhere written that the DPIA needs to be done externally. An organization internally can do a DPIA as long as they are able to prove to the auditor that we've considered all the aspects and post that have done a DPIA. So it's not a mandatory to be done by an external body.
Understood. I know that one of the requirements or one of the objectives of the session that came out of the poll was to understand roles and responsibilities, which obviously has been well articulated. It's always about action items and the next key steps for an organization. And in that, I think, Lalit, you talked about first thing being done is a gap analysis, right? And so if you would advise healthcare institutions or startups or others, what would be the effective way to get started? What would be the first 1 or 2 key action items that they should think about that allows them to get started towards compliance of the bill?
So, Dr. Anand, the date would be yesterday. The reason that I'll take the prime reason today is, although there is a lot of data today which is getting digitized. Data which is getting collected directly in digital form, but parallelly there is a lot of data which is currently in hard copy but in the process of getting digitized. And traditionally we've seen the security levels in hospitals are not as on the same line as a banking or a technology company. And moreover, the culture, technology organization, the culture is different. But in case of a hospital, the culture is more on serving the patient. Culture is more on saving lives than focusing on data, although slowly it is getting into the front part. So it is the main reason for yesterday is because there is a lot of work to be done. there are systems in the hospitals which do not talk to each other. So you have HMS, then you have different machines which have their own data. Then you have different OT equipments which are used, which capture their own data. So there's a different ecosystem altogether, capturing different sets of data, storing it in different format at different places. When an organization starts to do a gap assessment, alongside they should do a data mapping to say what are the touch points from where I'm getting the data. So for a hospital, it is an OPD where the data is coming in. It is an emergency. It is a teleconsultation. Their data from labs come into picture. People come in from tests. So there are multiple sources of data. You need to create a data mapping to say, where does my data collection start? Once the collection has started, let's say at an OPD, where does the data flow? How does it flow between one function to another? So the individual came to a physician. From physician, he goes to a cardiologist. From cardiologist, he goes to a different doctor. This is only the doctors which are changing. But is the data also moving from one place to another, or is it one system which everybody is accessing? So data mapping would help you to categorize where all is my data, and then create a roadmap to ensure that you comply with the law. Different hospitals, different sizes of data, different volume, different complexities. So based on the size of your organization, you should initiate that journey.
Understood. I think what I got as a quick summary is one, gap analysis and data mapping, which then automatically leads to a roadmap post that. Of course, it goes without saying that we are going to have the Lalits of the world that are going to also help go through this process of understanding what the roadmap can be once those two are done as a homework internally. Father Johnson, you had any question? I know you've unmuted.
I think we are almost reaching our time. Yeah, I don't have any specific question. Vinod, are you there? Are you with any questions?
Not really, Father. I have not really.
Okay, so I think let's conclude. This was a brilliant session, Mr. Lalit, and Dr. Anand, excellent moderator. I invite Mr. Ranjit Krishnan, the Group CEO, Kinder Hospitals, to say the word of thanks.
Yeah. Good evening to all of you. Thanks, Father Johnson, for this opportunity. So let me first thank Mr. Lalit Kalra for simplifying this Data Protection Act, and the content was very clear, Mr. Lalit, and thank you so much for that wonderful presentation. And thanks to Dr. Anand Sivaraman. I think there is nobody better than you to moderate this session. I think the highlight was your conclusion on every point. It was really fantastic, Dr. Anand. And I also would like to thank all the senior officials of CAHO, Dr. Vijay, Father Johnson, for conducting this program, and also all the panelists and all the participants who made this, session really interactive. Thanks to all of you. And finally, thanks to CAHO office for executing so nicely. So concluding, thanks to everyone.
Okay. We touched some 60 plus participants altogether, even though it's a very, very specific area of in a topic. I mean, well done. So thank you so much once again. Wish you all a great evening.
Thank you, everyone. Thank you for the opportunity.
Thank you.
Thank you.
Thank you,
everyone. Take care. Good day.
Good day. Good day.